Case 1, Nancy Moronez. March 1980, March 1984, 1985, pleaded guilty to 2019 Milwaukee County, Wisconsin. There are communities built on trust. Neighborhoods where parents wave to each other across driveways, where children play in yards within earshot of open windows, where the decision to leave a baby in someone else's care is made not with hesitation, but with the quiet confidence that comes from knowing your neighbors, knowing your community, knowing that the person watching your child while you are away is someone you can count on. Milwaukee, Wisconsin has always been that kind of city in many of its neighborhoods, a city of working families, of close-knit blocks, of people who show up for one another. That trust is what made what Nancy Moronez did so devastating. And that trust is what made it possible for what she did to remain hidden for 30 years. Nancy Moronez was a babysitter. She was a caregiver, someone that families in her Milwaukee County community trusted with the most precious thing they had. Over the course of 5 years, spanning from March of 1980 through 1985, 3 infants in her care lost their lives. 3 separate families. 3 separate tragedies. 3 separate moments when a parent received the worst news a parent can receive. And in each of those 3 cases, the official determination was the same: sudden infant death syndrome. SIDS. The diagnosis that means, in the language of medicine, that no cause could be found, that a baby simply stopped breathing in the night and did not start again. Justin Brunca was the first. He lost his life in March of 1980 while in Moronez's care in Milwaukee County. His death was attributed to SIDS. His family grieved. Life, as it must, eventually moved forward. Then came Brad Steege in March of 1984. Another infant. Another family. Another SIDS determination. And then, in 1985, came Katie Kozaniecki. A baby girl. Gone. SIDS again. 3 infants. 5 years. 1 caregiver. And a diagnosis that, in each case, quietly closed the file. The cases went cold. The years passed. Decades accumulated. The families of Justin Brunca, Brad Steege, and Katie Kozaniecki carried their grief forward into a future where the truth about what had happened to their children remained buried beneath a medical determination that had never asked the right questions. Nancy Moronez continued to live her life. She raised her own family. She had a daughter who grew up in the same household, breathing the same air, living under the same roof as the woman who had taken 3 lives and faced no consequence for it. And then, in 2015, that daughter made a phone call. Moronez's adult daughter contacted law enforcement. She told investigators something that stopped them in their tracks. Her mother had confessed. Not to a courtroom, not to a lawyer, not to a priest, but to her own child. Nancy Moronez had told her daughter what she had done to Justin Brunca, Brad Steege, and Katie Kozaniecki. She had told her that she had ended their lives because she could not handle their crying. 3 babies. 3 families destroyed. Because an infant, as infants do, had cried. The investigation that followed was the kind of work that demands patience, precision, and an extraordinary commitment to pursuing justice no matter how much time has passed. Law enforcement in Milwaukee County reopened the cases. They reviewed the original documentation. They interviewed witnesses. They worked with the information that Moronez's daughter had provided and built a case that, despite the passage of 30 years, was sufficient to bring Nancy Moronez before a court of law. When investigators confronted Moronez with what they had, she admitted it. She confirmed what her daughter had told police. She told investigators that she had ended the lives of the 3 infants in her care, that she had suffocated and drowned them because she could not manage their crying. 3 children who had never harmed anyone. 3 children whose only offense was being babies, being exactly what babies are supposed to be. In 2019, Nancy Moronez appeared in Milwaukee County Circuit Court and entered a guilty plea to 3 counts of homicide by reckless conduct. The court accepted her plea. She was sentenced to 30 years in prison in the Wisconsin Department of Corrections. She was in her 60s at the time of sentencing. The 30-year sentence, handed down in a Milwaukee County courtroom nearly 4 decades after the first infant lost their life in her care, represents the determination of the Wisconsin justice system that no amount of time erases the obligation to answer for what was done. The families of Justin Brunca, Brad Steege, and Katie Kozaniecki had spent decades not knowing. They had buried their children with a grief made complicated by the absence of answers, by the clinical neutrality of a SIDS diagnosis that gave them no one to hold responsible, no one to be angry at, no place to direct the profound and disorienting pain of losing an infant in the care of someone they trusted. The 2019 conviction did not give them back what was taken. Nothing could do that. But it gave them something that 30 years of silence had denied them. The truth, spoken aloud in a court of law by the person responsible for it. The case of Nancy Moronez is also a case study in institutional systems, in how a pattern of infant deaths in the care of a single provider went unexamined for years, in how SIDS diagnoses, while medically legitimate in the vast majority of cases, can in rare and devastating circumstances function as a shield behind which accountability disappears. The Wisconsin medical and legal communities have, in the years since this case came to light, continued to refine the protocols that govern the investigation of unexpected infant deaths. Protocols designed to ensure that the questions that were not asked in 1980, 1984, and 1985 are asked today, every time, without exception. Justin Brunka, Brad Steege, and Katie Kozaniecki deserve those questions. They deserve to have someone in authority ask, from the very beginning, why 3 infants in the same caregiver's home had lost their lives in the same way. That question was not asked for 30 years. It was finally asked because a daughter chose courage over silence. That courage and the justice it produced is part of the permanent record of Milwaukee County. The Wisconsin Child Abuse and Neglect Reporting Hotline is available at 1-800-913-SAFE, 1-800-913-7233. If you have information about harm to a child, please make that call. 3 families learn the hard way what happens when the right questions are not asked in time. Please like this video and subscribe to Cold Case Hour. Justin, Brad, and Katie deserve better. Their story deserves to be heard. Stay with us. Case 2, Nora Zylstra. March 9, 2014, Milwaukee County, Wisconsin. Milwaukee, Wisconsin. A Sunday in early March of 2014. The city was still in the grip of a long winter, the kind that settles into the bones of the upper Midwest and refuses to leave until well into spring. On a residential street near 76th and Morgan Avenue, a neighborhood of working families and modest homes, emergency responders received a call that would bring them to a scene they were not prepared for. Inside a home on that street, they found the body of 14-month-old Leonidas Fisher. His family called him Leo. Leo Fisher was 1 year old, barely past his first birthday. He was at the age when toddlers begin to find their legs, when the world starts to open up in ways that are thrilling and terrifying and endlessly fascinating, when the sound of a child's laughter fills a home with a kind of warmth that nothing else can replicate. Leo Fisher was at the beginning of everything. He had a whole life ahead of him. And on March 9, 2014, that life ended. His mother, Nora Zylstra, made the call to emergency services herself. She told them her son was unresponsive. When emergency responders arrived at the home near 76th and Morgan, they found Leo in a condition that was beyond their ability to reverse. The investigation that followed was conducted by the Milwaukee Police Department, which immediately recognized that the circumstances surrounding the toddler's death required serious scrutiny. What investigators discovered as they built their case painted a picture of a woman who had been deteriorating under the weight of a legal and personal crisis and had made a choice, a deliberate, conscious, catastrophic choice that took the life of her own child. In the days leading up to March 9, 2014, Nora Zylstra had been served with custody and paternity papers. The legal process that had been initiated around her son, around the question of who had rights to Leo, who his father was, what the future of his custody arrangement would look like, had, according to the investigation, pushed Zylstra into a state of severe psychological distress. She was experiencing profound paranoia. She was experiencing depression. She was, according to the account that emerged through the legal proceedings, in a state of mind that had detached her from any rational assessment of the choices available to her. She went online. She researched methods. She made a decision that no parent should ever make and that no legal proceeding, however frightening, however uncertain, however disorienting, could ever justify. Nora Zylstra suffocated 14-month-old Leo Fisher using a blanket and a pillow. Her own son, the child who had been the subject of the custody papers that had sent her into crisis. The baby boy who had no part in the adult legal dispute that surrounded him and no ability to protect himself from the person he trusted most in the world. The Milwaukee County District Attorney's Office prosecuted the case with the full weight it deserved. In June of 2014, just 3 months after Leo's death, Nora Zylstra appeared in Milwaukee County Circuit Court and entered a guilty plea to 1 count of first-degree reckless homicide. The speed of the resolution reflected both the strength of the evidence and the clarity of the legal determination that what had happened to Leo Fisher was a criminal act. Zylstra was sentenced to 25 years in prison in the Wisconsin Department of Corrections. 25 years for the life of a 14-month-old boy who had never done anything to anyone, who had simply existed at the center of an adult conflict he knew nothing about, who had been loved and then betrayed by the one person whose love should have been unconditional and absolute. The case of Nora Zylstra raises questions that mental health professionals, family law advocates, and child welfare experts in Wisconsin have continued to examine in the years since. The intersection of acute mental health crisis, family court proceedings, and the vulnerability of young children is a space where the system must be vigilant, where attorneys, judges, DHR workers, and healthcare providers must be alert to warning signs that a parent's deteriorating mental state may place a child in danger. Zylstra's psychological state in the days before March 9th did not develop overnight. It built over time. It expressed itself in ways that, in retrospect, may have been visible to those around her. The community, the legal system, and the healthcare infrastructure that surrounded her family in early 2014 did not intervene in time to save Leo. That failure, whoever or whatever bears responsibility for it, is part of Leo Fisher's story and part of the ongoing conversation about how Wisconsin protects its youngest and most vulnerable residents. Leo Fisher was 14 months old. He was called Leo. He had a name that his family had chosen for him with care and with love, a name that belongs to a tradition of strength and dignity. He deserved to grow into that name. He deserved every year that was taken from him on a cold March morning in Milwaukee. The National Alliance on Mental Illness Wisconsin chapter provides crisis resources and support for individuals and families navigating mental health emergencies. Their helpline is available at 1-800-950-NAMI. If you or someone you know is in psychological crisis, please reach out. Leo Fisher's case is a permanent reminder of what can happen when a mental health crisis goes unaddressed. Please like this video and subscribe to Cold Case Hour. Leo's story deserves to be heard beyond the courtroom where justice was delivered. Stay with us. Case 3, Azyia Zielinski. Discovered September 16, 2025, Milwaukee County, Wisconsin. There is a sound that is unmistakable to anyone who has ever lived near a family with young children. The sound of a baby crying. It cuts through walls, through closed doors, through the ambient noise of a neighborhood going about its business. It is the sound of a child communicating need, hunger, discomfort, fear, loneliness, in the only language available to someone too young to use words. It is a sound that, in normal circumstances, prompts an immediate response from the nearest adult. On a day in September of 2025, someone in Milwaukee heard that sound coming from a place where no baby should ever be. They called emergency services. And what law enforcement found when they responded to that call was one of the most disturbing child welfare situations documented in Milwaukee County's recent history. The call led officers to a commercial storage facility, a storage unit, the kind of space designed to hold furniture, boxes, seasonal items, the accumulated material of ordinary life, not living human beings. Certainly not children. Officers approached the unit from which the sound of crying had been reported. They found a padlock securing the door from the outside. They cut through it. Inside, in a windowless and unventilated space, they found 6 children. 6, ranging in age from 2 months old to 9 years old. They had been living in that storage unit for approximately 6 weeks. Their sleeping arrangement was a single bare mattress on the concrete floor. Their sanitation arrangement was a single plastic bucket. There was no ventilation. There was no natural light. There was no temperature regulation in a unit that, in the late summer heat of Wisconsin, would have reached temperatures dangerous to adults and potentially life-threatening to infants. The 2-month-old baby, 2 months old, barely past the newborn stage, entirely dependent on adult care for every aspect of survival, had been living in those conditions for 6 weeks. The children's mother was identified as Azyia Zielinski. The investigation that followed established the timeline of how the family had come to be living in the storage unit and the decisions that had led to 6 children spending 6 weeks in conditions that investigators described as wholly unsuitable for human habitation. The children's father, Charles Dupriest, was also identified as a party to the situation. The legal proceedings that followed took 2 different directions for the 2 adults involved. Charles Dupriest faced concurrent charges of felony neglect and illegal firearm possession, charges that, in combination, resulted in a sentence of 5 years in prison. Azyia Zielinski's case moved toward a resolution in March of 2026, when she appeared in Milwaukee County Circuit Court and entered a guilty plea to misdemeanor child neglect. She was sentenced to 18 months of probation. The outcome of Zielinski's case drew significant public attention and commentary in Milwaukee. Commentary focused on the question of whether the sentence reflected the severity of what those 6 children had experienced. 6 children, including a 2-month-old infant, locked in a storage unit for 6 weeks. 18 months of probation. The disparity between the 2 sentences, Dupriest's 5 years versus Zielinski's probation, reflected the specific charges that could be sustained under Wisconsin law against each individual and the particular role that each was determined to have played in the children's situation. What is not in dispute is what those 6 children experienced. 6 weeks without adequate living conditions. 6 weeks in a space designed for objects, not people. 6 weeks during which the youngest child, 2 months old, spent the entirety of their developmental window in an environment that no child welfare professional would consider acceptable for a single day, let alone 42 of them. The children were removed from the storage unit and placed in the care of the Milwaukee County Child Welfare System. The process of ensuring their physical recovery and addressing whatever longer-term effects their experience may have had on their development became the responsibility of the agencies and professionals charged with their ongoing care. The case of Azyia Zielinski and the 6 children of that Milwaukee County storage unit is a case that the Wisconsin child welfare community has examined carefully in the time since it came to light. Examined for what it reveals about the gaps in the system that allowed 6 children to spend 6 weeks in those conditions before a stranger's phone call to emergency services brought them to safety. A stranger heard a baby crying. A stranger made a call. Those children owe their rescue, at least in part, to someone who did not look away. Wisconsin's Child Protective Services can be reached through the Milwaukee County Department of Human Services at 414-220-7700. If you see something that raises concern about the welfare of a child, please make that call. Those 6 children needed someone to act. Someone did. Please like this video and subscribe to Cold Case Hour. These 6 children deserved safety and stability from the moment they were born. Their story is part of the public record because the public has a right to know what was done and what the system did in response. Stay with us. Case 4, Shyanna Brothers. Discovered August 13, 2025, Milwaukee County, Wisconsin. Neighbors know things. In the dense residential fabric of Milwaukee's urban neighborhoods, the blocks of apartment buildings and duplexes where walls are thin and common spaces are shared, neighbors develop an awareness of the rhythms of the people around them. They notice when something changes. They notice when a smell is wrong, when a sound is absent that used to be present, when something in the air of a shared building tells them that something on the other side of a wall is not right. It was neighbors who first raised the alarm in the case of Shyanna Brothers. It was neighbors who, in the days leading up to August 13, 2025, began to notice something deeply wrong emanating from Brothers' apartment near 27th and State Streets in Milwaukee. The nature of what they reported to authorities, a severe and persistent odor coming from the unit, was the kind of detail that experienced law enforcement officers recognized immediately as potentially significant. Milwaukee Police Department officers responded to the building. They knocked on Brothers' door. She answered. When the officers described the reason for their visit, the reports from neighbors about the smell, Brothers offered an explanation. It was food, she told them. Old food. The kind of thing that happens in any home when something gets forgotten in the back of a refrigerator or left out too long. There was nothing to worry about. Everything was fine. The officers were not satisfied. The smell that had prompted the neighbors' reports, and that was present even at the apartment door, was not consistent with the explanation being offered. They pressed. And eventually, Shyanna brothers directed them to a room in the apartment. A bedroom. The door was locked. What investigators found inside that locked bedroom, when they gained access to it, represented one of the most disturbing discoveries made by Milwaukee law enforcement in the summer of 2025. Inside the room, hidden inside a large cardboard box, were the remains of 10-month-old Rain Taylor. Rain was brother's daughter. She was 10 months old. She had been placed inside that box and left in that locked room. An autopsy conducted by the Milwaukee County Medical Examiner's Office determined that Rain Taylor had suffered severe physical harm to her head prior to her death. The manner in which she had lost her life was determined to be a homicide. The medical examiner's findings established that what had happened to Rain was not an accident, not a sudden medical event, not something that could be attributed to natural causes. Shyanna Brothers was arrested. She was charged with one felony count of hiding the corpse of a child, a charge that reflected what investigators could establish through the evidence available to them at the time of charging. The investigation into the full circumstances of Rain Taylor's death and the events that preceded the discovery on August 13th remained active as the legal proceedings moved forward through Milwaukee County Circuit Court. 10 months old. Rain Taylor had been in this world for 10 months. She had reached the age when babies begin to pull themselves up on furniture, when they reach for everything within arm's length, when their personalities begin to assert themselves in ways that make everyone around them fall a little more in love with them every single day. She was 10 months old. She was someone's daughter. She had a name, Rain, and she had a life that was supposed to unfold in front of her, full of ordinary and extraordinary moments, full of the simple accumulation of days that every child deserves. Instead, she was placed in a box in a locked room in a Milwaukee apartment while her mother told neighbors the smell was old food. The Milwaukee County justice system received the case with the seriousness it warranted. Law enforcement documented everything. The medical examiner's office conducted a thorough autopsy. The charges filed against brothers reflected what the evidence could establish. The legal process, however long it takes and however complicated the proceedings become, carries with it the obligation to answer for what happened to Rain Taylor. She deserved better. Every person who has ever held a 10-month-old baby, felt the weight of them, heard the sounds they make, watched the absolute trust with which they look at the person holding them, understands with complete clarity what was lost on the day Rain Taylor's life ended in that Milwaukee apartment. The National Domestic Violence and Child Abuse Prevention Hotline at 1-800-4-A-CHILD is available 24 hours a day for anyone with concerns about a child's safety. Rain Taylor's neighbors noticed something was wrong. They acted on it. Their vigilance brought her story to light. That kind of community awareness is one of the most important tools available to protect vulnerable children. Please like this video and subscribe to Cold Case Hour. Rain Taylor was 10 months old, and she deserved the whole world. Her name deserves to be spoken. Stay with us. Case 5. Angelica Belen. April 11, 2013, Milwaukee County, Wisconsin. West Allis, Wisconsin. A community that sits within Milwaukee County, bordered by the city of Milwaukee to the east. A working-class suburb where families have built their lives for generations, where apartment buildings and small homes line streets that feel, in the ordinary flow of daily life, safe and familiar and unremarkable. On April 11, 2013, a fire tore through a residence in West Allis. It was the kind of fire that fire departments train for, that communities dread, that leaves behind a changed neighborhood and changed lives. But what investigators discovered after the flames were extinguished was not simply a tragic accident. It was something far more complicated, far more painful, and far more preventable. Inside a second-story bedroom of the residence, emergency responders and fire investigators found the bodies of 3 children. 5-year-old Nayeli Belen, 4-year-old Adrian Belen, 4-year-old Alexis Belen, Adrian's twin brother. The 3 children had lost their lives from smoke inhalation. They had been found huddled together under a dresser. The instinct of young children to seek shelter, to find each other, to hold on. Frozen in a moment that no one who saw it could ever forget. The fire itself had been caused by faulty kitchen wiring. It was not set deliberately. The electrical failure that ignited the blaze was not something Angelica Belen had planned or anticipated. But the reason those 3 children could not escape when the fire broke out. The reason they were trapped in that second-story bedroom while smoke filled the room around them was entirely the result of a deliberate choice their mother had made before she left for work that morning. Angelica Belen had locked her children in the bedroom. Not accidentally. Not through some oversight or miscommunication. She had secured the bedroom door from the outside using a deadbolt, specifically to prevent 5-year-old Nayeli, 4-year-old Adrian, and 4-year-old Alexis from leaving the room while she was away at work. She had made a calculated decision that the solution to the problem of childcare was to lock 3 children, the youngest of whom was 4 years old, into a room from the outside and go to work. When the fire started in the kitchen, when the faulty wiring that would have been dangerous regardless of who was in the apartment ignited, those 3 children had no way out. The deadbolt that their mother had put in place to keep them from wandering the apartment while she was gone also kept them from escaping the smoke that was filling their room. They could not open the door. They could not get downstairs. They could not get out. They found each other under a dresser. And there they were found. The Milwaukee County investigation and the subsequent West Allis prosecution established the full picture of what had happened on April 11, 2013, and why. Angelica Belen was charged with 3 counts of child neglect resulting in death, 1 count for each child whose life was lost as a direct consequence of her decision to lock that bedroom door. The legal proceedings moved through the Milwaukee County court system over the months that followed. In September of 2013, Angelica Belen entered guilty pleas to all 3 counts. The court accepted her pleas. She was sentenced to 18 years in prison in the Wisconsin Department of Corrections. 18 years, 6 years per child, in the arithmetic of a sentencing that attempted to impose structure on something that resists any neat accounting. Nayeli, Adrian, and Alexis Belen had been left together in that room. They had faced the worst thing that can happen to a child. Complete vulnerability, complete helplessness, complete dependence on adults who were not there, together. The image of 3 children found huddled beneath a dresser is one that speaks to something deeply human about how children respond to fear. They move toward each other. They hold on. Even at 5 and 4 years old, they understood on some level that being together was better than being alone. They deserved so much more than what they got on April 11, 2013. They deserved a parent who found a different solution. They deserved to come home from wherever that morning took them. They deserved to grow up together, to be siblings for the rest of their lives, to share memories that stretched far beyond a second-story bedroom in West Allis. The Wisconsin Safe Kids organization and local fire safety advocacy groups have, in the years since this case, used it as a reference point in public education campaigns about home fire safety and child supervision. The lesson that Nayeli, Adrian, and Alexis's deaths carry, about the dangers of leaving young children unsupervised, and about the critical importance of fire escape planning in homes with young children, has reached families across Wisconsin. Their deaths, as heartbreaking as they were, have contributed to conversations that may have saved other lives. That is not justice, but it is something. Please like this video and subscribe to Cold Case Hour. Nayeli, Adrian, and Alexis deserved every year they never got to live. Their story is on this channel because they deserve to be remembered by more than those who knew them. Stay with us. Case 6, Tashae Goodman. May 2026, Milwaukee County, Wisconsin. In the spring of 2026, Milwaukee County Emergency Services received a call from a woman reporting that her 3-month-old son was not breathing. The call itself, a parent, a baby, an emergency, is the kind that dispatchers and first responders treat with the highest possible urgency. Every second matters when an infant stops breathing. Every moment between that call and the arrival of trained medical personnel is a moment in which the difference between survival and loss hangs in the balance. First responders arrived at the Milwaukee address. They found the 3-month-old boy unresponsive. Every effort was made. The infant did not survive. The woman who had made the call was Tashae Goodman. She was the baby's mother. Her initial account of what had happened centered on a common and tragic scenario. She had been sleeping near her infant son, and she believed she had accidentally rolled over him during the night. It was the kind of explanation that investigators encounter regularly in cases involving infant deaths, and that, when the medical evidence supports it, can lead to a determination of accidental death. First responders and investigators listened to her account, and then the medical examiner's office conducted its work. The forensic autopsy performed on Goodman's 3-month-old son did not support the account she had provided. What it found was something entirely different, something that took the case in a direction that no one who hears it forgets. The toxicology screening conducted as part of the autopsy revealed that the infant had died from mixed drug toxicity. Inside the baby's system, investigators found lethal concentrations of fentanyl, heroin, xylazine, and oxycodone, a combination of substances that no 3-month-old child should have any exposure to under any circumstances. The presence of those substances at the levels found in the infant's system was not consistent with accidental or incidental exposure. It was consistent with direct administration. Investigators examined the scene further. They examined the baby's feeding materials. Inside the infant's bottle, the bottle from which the 3-month-old had been fed, they found those same substances mixed directly into the formula. The baby's formula, the food that a 3-month-old depends on entirely for nourishment, that an infant drinks because an adult prepares it and offers it to them, and they have no ability to refuse or to know what is in it. Tashae Goodman was arrested. She was charged with first-degree reckless homicide and chronic child neglect. Her bail was set at $100,000 cash bond by the Milwaukee County Court. The charges reflected the full weight of what the evidence showed, that a 3-month-old infant had been placed in a position of catastrophic harm through the deliberate actions of the person responsible for his care and safety. The investigation was conducted by Milwaukee Police Department detectives in coordination with the Milwaukee County Medical Examiner's Office and the Milwaukee County District Attorney's Office. The evidence assembled, the toxicology results, the analysis of the bottle's contents, the forensic findings of the autopsy, presented a picture that the prosecution would carry into Milwaukee County Circuit Court. 3 months old. This baby boy had been in the world for 3 months. He had spent that entire time entirely dependent on the adults around him for everything, for warmth, for nourishment, for safety, for the basic conditions of survival. That dependency, which is the defining characteristic of infancy, is what made what happened to him possible and what made the accountability that followed so essential. The Milwaukee County justice system received this case and processed it with the gravity that the evidence demanded. The charges filed against Tashae Goodman, first-degree reckless homicide and chronic child neglect, represent the legal system's determination that what this infant experienced was not an accident and not an oversight. It was the result of choices. Choices that had consequences. Consequences that the Court of Milwaukee County is equipped and obligated to address. The Wisconsin Poison Control Center and Substance Abuse Intervention resources are available to any parent struggling with addiction. The Wisconsin Addiction Recovery Helpline can be reached at 1-800-593-6606. If you are a parent in crisis with substance use issues, please reach out before a child in your care is placed in harm's way. Help is available. This baby's case is a reminder of the stakes involved when it is not sought. Please like this video and subscribe to Cold Case Hour. This 3-month-old boy deserved the life that was taken from him. His story is documented here because accountability requires a public record. Stay with us. Case 7, Selena Doxzon. May 2025, Milwaukee County, Wisconsin. Every parent who has ever bathed a young child understands, at a visceral and immediate level, the calculus of supervision that governs those moments. Water and small children represent a combination that demands constant, uninterrupted adult presence. The bathtub, which looks like a safe domestic space, becomes in an instant a place of catastrophic risk the moment an adult's attention is diverted. Every pediatric safety organization, every parenting resource, every piece of guidance issued by child welfare professionals on the subject of water safety says the same thing. Never leave a young child unsupervised in or near water. Not for a moment. Not for any reason. In May of 2025, at a duplex near 53rd and Custer Avenue in Milwaukee, Wisconsin, Selena Doxzon placed her 1-year-old son and her 3-year-old son into a filled bathtub. Both boys in the water. Both boys young enough to be entirely dependent on adult supervision for their safety in that environment. And then she left. She went to the kitchen. She was going to cook breakfast. The kitchen and the bathroom were not the same room. Between the moment she left and the moment she returned, something happened in that bathtub. The 3-year-old walked into the kitchen. He was soaking wet. In the way that 3-year-olds communicate, through their physical presence, through the alarm that their state conveyed. He told his mother, without words, that something was wrong in the bathroom. Doxzon ran back. She found her 1-year-old son face down in the water. Unresponsive. Emergency services were called. First responders arrived and did everything within their power to help the infant. The 1-year-old boy did not survive the incident in the bathtub at the duplex near 53rd and Custer. Selena Doxzon was arrested by the Milwaukee Police Department and charged with felony child neglect resulting in death. The charge reflected the legal determination that the death of the 1-year-old boy was the direct and foreseeable consequence of a decision his mother made. The decision to leave 2 young children, one of them a toddler of 12 months, unsupervised in a filled bathtub while she cooked in another room. The word foreseeable matters in cases like this one. It is the word that carries the weight of the legal and moral analysis. Was it foreseeable that leaving a 1-year-old unsupervised in a filled bathtub could result in harm? The answer to that question, according to the standards of Wisconsin criminal law and the findings of the Milwaukee County investigation, was yes. It was foreseeable. It was preventable. And because it was both of those things, it was a criminal act. The Milwaukee County District Attorney's Office built the case around those facts. The investigation documented the circumstances of the incident. The duplex near 53rd and Custer, the filled bathtub, the absence of supervision, the sequence of events from the moment Doxzon left the bathroom to the moment the 3-year-old appeared in the kitchen wet, to the moment she found her youngest son face down in the water. Every element of that sequence was documented, analyzed, and placed before the Milwaukee County court system. He deserves that care. He deserves every support that the system can provide. He survived something that his brother did not. And he deserves to grow up in an environment that is safe, stable, and surrounded by adults who understand the weight of supervision and the obligation of care. The 1-year-old boy who lost his life in that bathtub deserved to grow up alongside his brother. He deserved to reach the age his brother had reached, to walk into kitchens and ask for breakfast, to accumulate the ordinary moments that make up a childhood. He was 1 year old. Safe Kids Wisconsin, a chapter of the National Safe Kids organization, provides water safety resources for families across the state. Their guidelines on bathtub safety, drowning prevention, and child supervision near water are available at safekids.org. The loss of a child near water is one of the most preventable tragedies in childhood safety. Please share those resources with every parent you know. Please like this video and subscribe to Cold Case Hour. This 1-year-old deserved every year that was taken from him. His story is on this channel because prevention begins with awareness. Stay with us. Case 8, Koch. Discovered July 13, 2023, Milwaukee County, Wisconsin. There is a specific kind of alarm that goes through a neighborhood when something happens that has no ordinary explanation. On a street in Milwaukee, Wisconsin, on a summer day in July of 2023, that alarm went through a neighborhood in the form of 2 children. 2 boys, 7 and 9 years old, walking down the street, unclothed, looking at the world around them with an expression that neighbors who saw them later described as the expression of people encountering ordinary daylight for what appeared to be the first time. Those 2 boys had come from inside a boarded-up house on that Milwaukee street. They had broken out through a window. And what investigators found when they entered that house in response to the neighbors' reports would take time to fully comprehend, because what the house contained was not simply evidence of neglect, but evidence of a years-long pattern of deliberate isolation and confinement that had denied 2 children access to almost every fundamental element of normal human development. Koch was the boy's mother. She was 30-something years old, living in that Milwaukee home with her boyfriend and the 2 children she had sealed away from the world behind boarded windows and locked doors. The 7-year-old and 9-year-old boys inside that house had never attended school. Not once. Not a single day. They had never seen a doctor. No pediatric appointments. No vaccinations. No medical care of any kind. They lived in conditions that investigators described as severely deteriorated, surrounded by piles of garbage, hoarding material, and waste that had accumulated over what appeared to be years of neglect. The house itself told the story. Boards over the windows. A physical barrier between the children inside and the world outside. A deliberate architectural choice to ensure that no one looking at the house from the street could see in, and no one inside could easily get out. The boys had lived within those walls, in those conditions, for what the investigation determined was an extended period. They had grown in that environment. They had aged in it. They had reached 7 and 9 years old without ever sitting in a classroom, without ever visiting a pediatrician's office, without ever having the kind of contact with the broader community that most children take entirely for granted. On July 13, 2023, something shifted. The boys got out. They broke through a window, an act that required initiative, physical effort, and whatever reservoir of instinct told them that the world outside the boards was something they needed to reach. They walked down the street. Neighbors saw them. Neighbors called for help. Milwaukee Police Department officers and child welfare investigators responded. They entered the house. They documented what they found. They removed the children and placed them in the care of Milwaukee County Child Welfare Services. The investigation that followed built the case against Katie Koch and her boyfriend that would ultimately be brought before Milwaukee County Circuit Court. Koch entered a guilty plea to felony child neglect and false imprisonment charges that reflected the two core elements of what had been done to those boys. The neglect was documented in the conditions of the home, the absence of education, the absence of medical care, the physical environment in which the children had been living. The false imprisonment charge reflected the boards on the windows, the locked doors, the deliberate physical barriers that had kept two boys from accessing the outside world. The sentencing in Koch's case reflected the Milwaukee County Court's determination of the appropriate consequence for years of deliberate isolation and neglect of two children who are now, thanks to the neighbors who acted on what they saw, in a position to begin the long process of recovery and reintegration. The two boys who walked out of that house on July 13, 2023, had never experienced a normal school day. They had never had a wellness checkup. They had never had the kind of ordinary social interactions with classmates, with neighbors, with the broad fabric of community life that formed the developmental foundation of childhood. What they had experienced instead was years of confinement in a deteriorating house with boarded windows. They are now in the care of a system that owes them every resource available to address the years of developmental experience they were denied. They got out. They broke through a window and walked down a street and encountered a world that, by all accounts, looked entirely new to them. That act, of two boys, 7 and 9, deciding on a summer day that they were going to find the outside world, is one of the most quietly remarkable moments in any of the cases documented in this episode. Wisconsin's Education for Homeless Children and Youth program, operated through the Department of Public Instruction, provides support for children who have missed significant periods of schooling. Their resources are available at dpi.wi.gov. Those two boys deserve every educational opportunity that was denied to them during the years they spent behind those boards. Please like this video and subscribe to Cold Case Hour. Those two boys found their way out. They deserve to never have been locked in. Their story is on this channel because the system that failed them for years owes them accountability. Stay with us. Case 9, Daquela S. Collins. May 2026. Guilty plea May 26, 2026 Milwaukee County, Wisconsin. Milwaukee, Wisconsin. May of 2026. A home on the north side of the city. A 6-year-old boy. And a firearm that should never have been where it was. The case of Daquela S. Collins arrived in the Milwaukee County legal system through one of the most devastating and preventable pathways that prosecutors and child welfare advocates encounter. The intersection of illegal firearms, inadequate safety measures inside a home with young children, and the catastrophic consequences that follow when a child finds a weapon that an adult left within reach. On a day in May of 2026, a 6-year-old boy inside a Milwaukee home discovered a loaded firearm. It had not been secured. It had not been locked away. It had not been placed in any of the configurations, trigger locks, gun safes, locked storage separate from ammunition, that firearms safety guidelines and Wisconsin law require when a loaded weapon is present in a home with children. The 6-year-old found the gun, and he used it. The boy did not survive. The investigation conducted by the Milwaukee Police Department in the aftermath of the tragedy did not stop at the immediate circumstances of the shooting. Detectives dug deeper. What they found added an additional and significant dimension to the legal accountability that would follow. The firearm that the 6-year-old had found was not legally owned by anyone in that household. The investigation established that Daquela Collins had acted as what law enforcement terms a straw purchaser, meaning she had purchased the firearm on behalf of another individual who was legally prohibited from owning one. She had used her own legal eligibility to buy a gun for someone who could not legally buy it themselves. That gun had then ended up in a home with a 6-year-old boy, unsecured, within reach, with consequences that cannot be undone. On May 26, 2026, Daquela S. Collins appeared in Milwaukee County Circuit Court and entered a guilty plea. She pleaded guilty to felony child neglect resulting in bodily harm and to the illegal straw purchasing of a firearm. The plea was accepted by the court. Sentencing proceedings followed in the Milwaukee County system. The case of Daquela Collins sits at the intersection of two overlapping crises that have shaped the conversation about public safety in Milwaukee and in cities across the country. The crisis of illegal firearms entering communities through straw purchasing arrangements, and the crisis of children in homes where unsecured weapons are accessible. Both of those crises, in this case, converged on a single moment in a Milwaukee home in May of 2026. The 6-year-old boy who lost his life was not a participant in either crisis. He was a child. He was 6 years old. He found something that an adult left where he could find it. And he did what 6-year-olds do with objects that are new and unfamiliar and that no one has told them are dangerous. The outcome of that moment is the outcome that firearms safety experts, child welfare advocates, and law enforcement professionals spend their careers trying to prevent. The Milwaukee County legal proceedings established accountability for both dimensions of what Collins had done, the failure to secure the weapon and the role she had played in placing an illegally acquired firearm in a home with a young child. The guilty plea to both charges created a record that reflects the full scope of her legal responsibility. In Wisconsin, firearms must be stored securely in any home where children are present. The Wisconsin gun storage law requires that firearms be stored in a manner that prevents access by children. Violations of that law, particularly when they result in harm to a child, are prosecuted as criminal offenses. The resources of the Be Smart campaign, a national firearms storage safety program operated in partnership with Everytown for Gun Safety, are available at besmartforkids.org. Secure storage saves lives. This 6-year-old's life should have been saved. Please like this video and subscribe to Cold Case Hour. This 6-year-old boy deserved to grow up. He deserved to be protected inside his own home. His story is on this channel because accountability for how firearms are handled in homes with children is a community responsibility. Stay with us. Case 10, Anitra Burks. January 2026. Sentenced February 2026, Milwaukee County, Wisconsin. There are verdicts that a community waits for. Cases that enter the public consciousness and stay there. That become the subject of conversations at kitchen tables and in community centers and in the offices of advocacy organizations, while the legal process moves at its deliberate, careful pace toward a conclusion. The case of 6-year-old Zane McAtee Adams was one of those cases in Milwaukee, Wisconsin. And on a day in February of 2026, the Milwaukee County justice system delivered the verdict and the sentence that Zane's memory and the community that had followed his case demanded. In January of 2026, Anitra Burks brought 6-year-old Zane McAtee Adams, her stepson, to Children's Wisconsin, the pediatric hospital that serves as one of the primary medical institutions for Milwaukee's youngest residents. She told hospital staff that he had stopped breathing. Medical personnel at Children's Wisconsin received the child and immediately began their assessment. What they observed in the course of examining Zane told them something that their training had prepared them to recognize and their professional obligation required them to report. Zane McAtee Adams had severe and widespread bruising across his head, across his torso, and across his limbs. The distribution and nature of those injuries were not consistent with a single incident or with an accidental cause. They were consistent with a pattern, a sustained, recurring pattern of severe physical harm that had been inflicted on a 6-year-old boy over a period of time. Zane did not survive. He lost his life shortly after arriving at Children's Wisconsin. The Milwaukee Police Department and the Milwaukee County District Attorney's Office launched the investigation that followed with the full resources that a case involving the death of a child demands. The investigation established what the medical evidence had suggested. that Zane Adams had experienced a prolonged pattern of severe physical abuse in the home where he lived, that the injuries which ended his life on the day Burks brought him to Children's Wisconsin represented the culmination of that pattern, and that the person responsible for that pattern was Anitra Burks. The case went to trial in January of 2026 before a Milwaukee County jury. The prosecution presented the medical evidence, the testimony of the medical professionals who had examined Zane, the investigative findings, and the documentation of the injuries he had sustained. The defense offered its response. The jury deliberated, and they returned verdicts on all counts. Anitra Burks was convicted of first-degree intentional homicide and physical abuse of a child, the most serious charges available under Wisconsin law in a case of this nature. The jury found, on all counts, that the evidence supported conviction. There were no acquittals. The verdict was complete. In February of 2026, Anitra Burks appeared before a Milwaukee County judge for sentencing. The judge, having reviewed the jury's findings, the pre-sentencing report, the medical evidence, and the impact of Zane Adams's death on those who loved him, handed down the sentence that Wisconsin law prescribes for first-degree intentional homicide: life in prison without the possibility of parole. Life without parole. In Milwaukee County, Wisconsin, for what was done to a 6-year-old boy. The sentence reflected the jury's unanimous finding that what had happened to Zane Adams was not an accident, was not a single moment of lost control, was not a tragedy in the sense of something unforeseen and unavoidable. It was intentional. It was sustained. It was directed at a child who had no ability to leave the home where it was happening, no ability to call for help, no ability to protect himself from the person in whose care he had been placed. Zane Adams was 6 years old. He had a name that belonged to him, that people who loved him used when they called for him and spoke about him and thought about what his future might hold. He went to Children's Wisconsin on a January day in 2026, and he did not come home. He deserved to come home. He deserved to grow up. He deserved every year that the Milwaukee County jury system, in its verdict, formally acknowledged had been wrongfully taken from him. The sentence of life without parole handed to Anitra Burks does not return those years. Nothing can return them. What it does is place on the permanent record of Milwaukee County, Wisconsin, the determination that what was done to Zane Adams was among the most serious criminal acts that the legal system is equipped to address, and that the person responsible for it will spend the remainder of their natural life in the custody of the Wisconsin Department of Corrections. That is what justice looks like in a case like Zane's. It is not enough. It never is. But it is what the system can do. And this channel will always document what the system does, because the children who cannot speak for themselves deserve to have their stories told, their names spoken, and their cases followed all the way to the end of the legal road. The Child Help National Child Abuse Hotline is available 24 hours a day, 7 days a week at 1-800-4-CHILD, 1-800-422-4453. If you know a child who may be experiencing harm inside their home, please make that call. Zane Adams deserved someone to make that call. He deserved intervention before January of 2026. Thank you for watching Cold Case Hour. If this episode moved you, if it made you think, if it made you want to do something, please like this video and subscribe to this channel. Share it with someone who needs to hear these stories. Leave a comment below and tell us which case you believe deserves more attention from the public. These victims were real. Zane was real. Justin, Brad, and Katie were real. Leo was real. Rain was real. Nayeli, Adrian, and Alexis were real. Every child in every case documented in this episode was a real person whose life mattered and whose story deserves to be part of the public conversation about child safety, community responsibility, and the obligation of every adult in every community to protect the children around them. This has been Cold Case Hour. Real cases, real courts, real verdicts. We will be here for the next one.